Prince Harry spent years taking Britain's tabloid press to court. He accused one newspaper group of phone hacking, deception, surveillance, and paying people for private information. The case involved 97 separate allegations, 7 famous claimants, and a trial lasting 46 days. Then the judgment arrived. Every claim was dismissed. The court said the evidence did not prove unlawful information gathering. Now, the publisher wants tens of millions of pounds in legal costs, and Harry has called the ruling a whitewash. Tonight, we're examining what actually happened in Prince Harry's case against Associated Newspapers, why the evidence failed, and what the loss could mean next. Welcome to the podcast, You Can't Unhear. Disclaimer before we begin. This was a civil privacy case, not a criminal prosecution. The claimants had to prove their allegations on the balance of probabilities. That means showing it was more likely than not that unlawful information gathering occurred. They did not have to meet the criminal standard of proof beyond a reasonable doubt. Even under that lower civil standard, the judge concluded they had not proved their case. The lawsuit was brought by 7 public figures. They included Prince Harry, Baroness Doreen Lawrence, Elton John, David Furnish, Elizabeth Hurley, Sadie Frost, and former politician Simon Hughes. Their target was Associated Newspapers Limited, publisher of the Daily Mail, the Mail on Sunday, and MailOnline. The claimants alleged that journalists or people working for the newspapers had obtained private information through unlawful methods. Those alleged methods included phone hacking, using deception to obtain confidential records, paying corrupt officials, and instructing private investigators to gather information illegally. Associated Newspapers denied all wrongdoing. It also argued that many claims had been filed too late. For Prince Harry, this lawsuit formed part of a much wider campaign against the British press. He has repeatedly said aggressive tabloid behaviour damaged his life, his relationships, and his mental health. He has also connected his legal battles to the treatment of his mother, Princess Diana, who died in 1997 while being pursued by photographers in Paris. Harry previously won damages in a phone hacking case against Mirror Group newspapers and reached a settlement in another case involving the publisher of The Sun. But this case was different. Associated Newspapers had never made the kind of broad admissions seen in some earlier hacking litigation. Harry and the other claimants, therefore, had to prove the alleged wrongdoing article by article, incident by incident. That became the defining problem. The court was not being asked to decide whether unlawful behaviour had ever existed anywhere within the British press. It was not conducting a public inquiry into the historic culture of Associated Newspapers. The judge repeatedly said the trial had to remain focused on the individual claims actually pleaded. For each disputed article or incident, the claimants had to prove that private information had been obtained unlawfully and connect that conduct to the journalist or investigator involved. They pointed to the historic use of private investigators, missing records, past newspaper practices, and similarities with misconduct uncovered elsewhere. But Mr. Justice Nicklin warned against what he described as inference built upon inference. Even evidence showing that one investigator had acted unlawfully in another context would not automatically prove that a particular article in this case had been unlawfully sourced. The judgment made one point especially clear. Private information does not automatically equal illegally obtained information. A newspaper may receive personal details from friends, employees, public records, press officers, people present at an event, or sources willing to speak confidentially. If the publisher could not remember or document the source decades later, that did not allow the court to assume phone hacking or deception had occurred. The claimants needed convincing evidence establishing an unlawful route. Suspicion, even understandable suspicion, was not enough. Associated newspapers called journalists to explain how stories had been sourced. The court accepted their evidence and their denials of unlawful information gathering. In many instances, the judge found that a lawful source remained realistically possible. That alone was enough to prevent the claimants from proving that the information must have come from an illegal method. This did not mean the court declared every historical practice of every newspaper innocent. The judgment specifically avoided making a broad finding on whether unlawful information gathering had once been widespread within associated newspapers. It ruled only on the claims placed before it. And on those claims, the evidence failed. One of the most damaging parts of the case involved private investigator Gavin Burrows. Statements attributed to Burrows had played an important role in the claimants' allegations. Those statements appeared to describe illegal work carried out for newspapers, including the gathering of private information. But Burrows later challenged important parts of the material attributed to him. He said one statement did not contain his signature and disputed claims that he had worked for associated newspapers in the way alleged. The procedural history became complicated. At first, the claimants sought to rely on statements attributed to Burrows as hearsay. Later in the trial, they decided to call him as a live witness. The judge allowed that only under tightly controlled conditions because of the late change in strategy. Once Burrows gave evidence, the claimants could rely on earlier statements only to the extent that he personally adopted them. Where he refused to confirm their contents, those claims lost much of their evidential force. This mattered because Burrows had been linked to some of the most serious accusations. If the person supposedly responsible for unlawful activity would not support the statement attributed to him, the court could not simply treat that statement as proven fact. Associated newspapers argued that this revealed fundamental weaknesses in the way the case had been assembled. The judge did not accept the broader allegations that senior associated executives had lied to the Leveson inquiry either. Those accusations also failed for lack of proof. Prince Harry's own claims involved 14 articles published between 2001 and 2013. His lawyers argued that some contained information so private that unlawful sourcing was the most plausible explanation. Associated newspapers presented alternative accounts, including contact with legitimate sources, known relationships between Harry and journalists, and information circulating among royal correspondents. The judge concluded that Harry had not proved his allegations. His claims were dismissed along with the rest. On July 7, 2026, the High Court delivered its judgment. All of the claimants' claims were dismissed. The court said they had failed to prove the pleaded allegations of unlawful information gathering. For some claims involving Simon Hughes and Sadie Frost, the judge also concluded they would have been filed too late, even if the underlying allegations had been proved. Associated newspapers called the result a major victory for its journalists and for press freedom. Harry and Doreen Lawrence responded with a joint statement describing the judgment as unwarranted, unexpectedly favourable to the newspaper, and a whitewash. That statement received significant criticism. But calling the judgment a whitewash does not automatically create a new offence, void insurance, or determine the costs ruling. Those consequences have been widely speculated about, but they have not been established by the court. The next battle is money. Under the usual rule in English civil litigation, the losing side is generally ordered to pay a substantial portion of the winner's reasonable legal costs. Associated Newspapers says its legal expenses have reached approximately £34.5 million. It is asking for costs on an indemnity basis. That phrase does not mean the publisher automatically receives every pound it's spent. Costs must still be assessed, but indemnity costs are more favourable to the winning party than standard costs. Questions about whether an expense was reasonably incurred are resolved more generously in the winner's favour, and proportionality restrictions are less protective of the losing side. Associated argues that this higher basis is justified because the claimants advanced extremely serious allegations that ultimately failed. The publisher has asked for an interim payment of £10 million, while the full cost assessment continues. The claimants accept that an interim payment will likely be required, but have argued for a lower amount of approximately £8 million. Their lawyers have called Associated's total bill excessive, noting that it exceeded earlier cost budgets. The 7 claimants reportedly hold litigation insurance covering around £16 million. If Associated ultimately recovers close to its claimed amount, there could be a major uninsured shortfall. But it would not necessarily fall entirely on Prince Harry. The court must determine how costs are divided among all 7 claimants, their insurers, and potentially their legal arrangements. This is why headlines claiming Harry personally owes $40, $50, or $75 million are misleading. The £34.5 million figure is the publisher's claimed total cost for defending the case against all 7 claimants. It is not yet a final court order. It is not automatically Harry's individual liability, and there has been no judicial finding that bankruptcy is imminent. The financial consequences could still be extremely serious, but the exact burden will depend on the costs, judgment, insurance coverage, and how liability is allocated. The claimants also want to appeal. They argue that the court applied an overly restrictive approach to circumstantial evidence, placed too much weight on journalists' explanations, and failed to appreciate the difficulty of proving covert misconduct from events that occurred many years ago. Associated Newspapers says the judgment was detailed, evidence-based, and should stand. The judge has postponed deciding whether to grant permission to appeal until the costs issues are resolved. Even if the trial judge refuses permission, the claimants may attempt to seek it from the Court of Appeal. The case leaves 2 competing narratives. For Harry and the other claimants, the defeat does not erase their belief that they were victims of unlawful press intrusion. They argue that old misconduct is difficult to prove because records disappear, memories fade, and covert behaviour leaves little documentation. For Associated Newspapers, the case demonstrates the danger of making grave accusations based on assumption, pattern, and suspicion rather than article-specific proof. It is also important not to confuse the result with Harry's other media cases. He has successfully proved unlawful information gathering against another newspaper publisher. He has also received settlements and admissions elsewhere. Losing this lawsuit does not mean every complaint he has ever made about the British press was false. It means that these 7 claimants failed to prove these particular allegations against Associated Newspapers. Thanks for joining me. Until next time, stay curious, stay safe, and I'll see you on the next episode of the podcast You Can't Unhear.